When it comes to creative lawyering, coming up with ideas and strategies that no one has tried or even heard of before, my hat is off to Dan Weinstock. I don't know anyone who does it as well or who comes up with the ideas like this so frequently. And it's my pleasure to present Dan to speak about the use of shadow juries.
What if you had just put on a witness on direct and you didn't quite finish and you had a lunch break and you felt like you covered everything pretty well, but one or two areas, maybe the lawyer's trying the case with you says, I don't think you really got into this enough. I don't think they understood it real well. Or here's an even better example. What if your jury is deliberating and there's an $8 million offer on the table and you've got a really tough decision to make? Who wants to talk to the jury then? Absolutely, no brainer. So that's really what a shadow jury is about. I one time, that was this Upsy case, did a shadow jury. So I'm going to tell you about that experience, what I learned from that, first of all with sort of just the mechanics. And here's how it works. You have a jury consultant, and the jury consultant selects actual people from the Philadelphia jury pool. He then looks at your actual jury and selects from the bigger group a smaller group that closely mimics your real jury. So now you've got a pretty good sample, but they don't know why they're there. They're told that they're doing some research project, something else, and they really truly have no idea, you can tell, who they're working for or even why they're doing what they're doing. But what they do is they sit in the courtroom whenever the real jury is there, and then every day at lunch break, they're debriefed. At the end of the day, there's an extensive debriefing, and we can actually tailor specific questions to these jurors and get answers, and answers that we feel are pretty objective. So here's how we did it in this case. Facts of the case. Woman is 36 weeks pregnant. She comes into Pottstown Memorial Medical Center, and she pretty clearly has a placental abruption. It's an emergency. There's no question about that. The doctor does an ultrasound to see what the fetal condition is. 36 weeks is close enough. The baby's going to be fine if delivered before the placental abruption really harms the baby. And the doctor does an ultrasound and finds no heartbeat. So he says the baby's dead. Well, he orders a confirmatory ultrasound to be done by the radiologist with different equipment and a radiology tech. And that's done 81 minutes later. They find the baby's not dead, the baby's alive. So they do a stat C-section, but there has been an 81-minute delay at this point, and the baby's born with profound injuries. We have an agency theory that we believe in. We think it's strong. We think it will probably win the day, but we're not going to leave it alone at that. So we did some deeper research and investigation, and what we learned is that the equipment available to that doctor in the labor and delivery triage department was old equipment. And in this case, they only provided one transducer. Different transducers are used for different purposes. They provided for Dr. Tui a 3.5 megahertz transducer, which is what you would use for a typical patient. For most patients, it's fine. But as you go deeper, you don't penetrate as well. With a lower frequency transducer, you would be able to see better down here. So our theory against the hospital, other than agency, was that the 3.5 megahertz transducer was inappropriate for this case because she was an obese woman, so there was fatty tissue up here, and the fetus was lying on its side. With the heart, we estimated 12 to 17 centimeters below the skin surface. So our argument was that the equipment the hospital provided to this doctor was below the standard of care because it only provided what was good for most patients, not for every patient, and of course not for this patient. So what did we want to do with the shadow jury? We want to evaluate all of the testimony and all of the evidence as it's coming in. We want to make changes on the fly. We want to take lunch breaks and say, hey, I'm glad I got this lunch break, or maybe even finesse this lunch break, because now I can go back and finish what we didn't cover as well as we should have, or what some of these shadow jurors aren't really sure about yet. We can then evaluate the case for settlement later on. What happens is every day, these jurors are filling out handwritten notes, and every day we're getting to see them. Here are some of the notes that the shadow jurors gave us. The only issue that I have is with Dr. Tui's demeanor. He seems to be disconnected from the reality of this case. To me, that proves that what Ms. Upsy has stated to be true. Notice Dr. Toohey looking despondent, does not look confident. Why didn't Dr. Toohey console or show some type of sympathy when Paris, which is the baby, was in the courtroom? And the point there is that he didn't look caring, and that was one of our themes in the case. So we thought that he was a bad witness. We thought the jury didn't like him, and what we learned from the shadow jury is that we were right. And one of these shadow jurors did us a wonderful service. I was calling what they did wrong, a wrong interpretation of something, and this juror helped me out. I don't think, quote, wrong is the proper term here. Rather, limited would be the proper word. Alternative equipment should always be available and trained personnel to use it. Hospital guilty, not the doctor. So what that did is it allowed us to say, these are the theories we're really going to push, and we're going to back off a little bit on some of the other theories. We closed the evidence as it worked out on a Friday, which was great. We had the entire weekend to prepare for closings on Monday. So we've got this offer of $8 million. We're pretty convinced that if we move much, we can get more money on the table. The jury consultant sat and interviewed every single shadow juror for an hour. And I listened to every word. And I really felt like I had unbelievable intel. I knew exactly what they thought. I knew exactly what they didn't think. I knew which arguments were strongest. And I felt like we were able to give our client advice at a level that I've just never felt comfortable having that degree of confidence in. The verdict sheet: do you find Victoria Upsey reasonably believe that Dr. Toohey was the agent or ostensible agent of defendant Pottstown Hospital? This is the agency question, and we got the yes. We're feeling great. Now let me show you the 5 longest seconds of my life. Do you find the following parties were negligent? Dr. Toohey? No. Well, our shadow jury tagged them. The client kind of relied on some advice we gave them. So just as Scott was sort of coming over to me with the paddles, doing CPR, part C comes back, and it's Dr. Toohey's not negligent, but Pottstown Hospital is. And then D puts 100% of the responsibility on Pottstown Hospital. And then the damages, of course, as you know, were pretty good. My overall impression is I left this trial feeling like I cheated. It was almost like I took an exam having purchased the answers in advance. So for the right case, at least based on my limited experience, this was an unbelievable thing to do.